And can we go back to the bribery statute? I, like you, understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That is correct. And it's an extremely
official building. It's a very limited mention of the
president. And it really, I think,
so, as I understand this, there's two very limited provisions mentioning the president is included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the fence.
Now, Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think
that's a tautology you can't escape.
Justice Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly. That's the point, which is if he's not covered by the criminal law, he can't be impeached for it, for violating it. All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was analyze what powers were being given to in the lawsuit, and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept the bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context-specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, this is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right. Could I go back to your brief? And going back to what some of my colleagues have asked you, there appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
that
correct?
Is
You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that that have to do with the president in law is that he shall take care that the law be faithfully executed, correct?
That is right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
All right.
Counsel.